Good afternoon, everyone, and good afternoon, Justice Carelse. How are you? Please switch on your mic.
Okay, there you
Thank
go.
you.
Thank you. Good afternoon, DCJ and the rest of the commissioners.
Let me first apologize on behalf of the Commission for keeping you waiting. You were supposed to be interviewed first thing this morning, then that time changed, and here we are. So let's do this. Are you comfortable?
I am, thank you, DCJ.
You hold 2 degrees, a BA and an LLB
That's
from the University of Durban-Westville. You have a long judicial career which started in 1998
That's right, DCJ.
when you joined the magistracy in the Johannesburg Magistrates Court.
Yes, that's right, 26 years ago.
And well, just explain a bit to me. It says magistrates, criminal court / family court, Mitchell's Plain.
Okay. I was in Johannesburg and then I got transferred to Mitchell's Plain. And I was exposed to all areas of law, family court, civil court, criminal court. In Mitchell's Plain in particular, I was exposed to those courts.
All right, but then before you joined the magistracy, you had done a few other things outside the legal field. You were an underwriting clerk for one insurance company and a junior banker at some stage.
That's right. I worked for an insurance company as a trainee underwriter. I'd finished my BA degree and went to find a job in Johannesburg and studied for about a year, saved some money, and came back to complete my LLB degree at the University of Durban-Westville.
And then you became a public prosecutor.
I became a public prosecutor, I think, in 1994. And I...
And you remained with the magistracy for 6 years before you joined the Johannesburg High Court.
That's right.
Okay. Was that in 2008?
2008, yeah. I was one of the successful candidates on the Bridget Mabanta / Pius Langa Sprint Women Judges program. And that was in 2008. And I never went back to the magistracy after that.
And you remained in that court until 2021 when you ascended to the Supreme Court of Appeal.
That's right, DCJ.
You had intermittently acted in the land claims court during your time at the High Court.
That's right, over a 12-year period.
Can you just give us the time periods? When did you work there?
Okay, so in 2008, I completed the theory of the aspirant judges conference program. And afterwards, I was mentored. I was assigned to Judge Gildenays, who was at the Land Claims Court. At the time, I knew absolutely nothing about land issues. And so to speak, I was thrown into the deep end. And from about 2009, I think I got appointed on the 26th of August 2009. I was then seconded to the Land Claims Court. I would serve time in the High Court and then serve time in the Land Claims Court. So I got there when just the late Judge Baum was still the head of the court. And that was, 2009. So I did stints in both the High Court and the Land Claims Court for a period until 2021 when I was elevated to the Supreme Court of Appeal.
All right. I'm sorry, I just overlooked one important aspect of your CV, your stint as a regional magistrate. And I want to mention in that regard a fact you told us about the last time you were here, that you actually took that job to set up a sexual offences court in that area.
Okay. At DCJ, my career path, I've actually been actively involved in areas of the law that were, gender-based violence. In fact, at the beginning of my stint as a magistrate, I was seconded to set up guidelines for the Domestic Violence Act. In fact, we set up the Domestic Violence Court in Mitchell's Plain, the first. It wasn't in Wynberg in Cape Town, it was in Mitchell's Plain at the time. And thereafter, I was seconded to set up the Sexual Offences Court in the Cape Town Regional Court. It was, I think, also the first of the Sexual Offences Court. And from there, I was then transferred to, or I think it was the other way around. I set up the Sexual Offences Court in Tembisa as well. It was the specialist court dealing with sexual violence matters for a number of years.
And in 2018, you were lured to the Supreme Court of Appeal and acted there.
Yes,
For
under
how
your
long?
stewardship. Yes, yes, DCJ.
All right. In 2020, you acted as the Deputy Judge President in the Johannesburg High Court, not so?
That's right, DCJ. That was in the height of COVID. I was asked to act during that period. It was a very challenging period, but really one of the highlights of my career.
Yeah, and I mean, you mentioned that one of the law bodies who have commented on your candidature
Yes.
say you served in that position with distinction, to use their words.
Thank you.
How long was that acting stint?
About 6 months, because then I was asked to act again in the SCA, which was from the 1st of December 2020, if I'm not mistaken.
What was the nature of the duties you did during that time?
As a DCJ, I
as
managed
DJP.
I managed about 60 judges. I had to allocate work. In fact, Gauteng in particular, I was also fortunate because I was one of the pilot judges to implement, that had to be trained to implement a case line. So fortunately for Johannesburg at the time, when COVID came, we had already had some training, and of course we went straight into hearing matters. I think Johannesburg was we didn't operate for a week or maybe 2 weeks, but thereafter we were able to do hearings virtually. So I had to manage case lines, I had to manage judges who for the first time I had to deal with working online. It was very challenging, but I think we all got on with the job. I had a great relationship with colleagues. I think, I'd like to believe that I had great support from them because, as I said, during that challenging period of time, colleagues bought into the whole idea of online court. And yeah, our court ran like it would run like on a normal day. So, the other thing that I found a bit challenging was initially I found that, the male judges were not very receptive. That I was appointed as the acting DJP, but as time went, and I think they came around. I had to assert myself. I'll give you an example. I would tell a colleague, here's an allocation, and they would say, I'm busy with something else. I've played my own role. I'd send the file down and I'd say, well, deal with the matter that's been allocated to you. So those are the challenges that I had. So I had to be firm and assert myself, which I did.
I recall that there was an expectation that you'd make yourself available for permanent appointment to that position when it was advertised.
Yes.
But when the time came, you declined the invitation. May I ask why? And I know that a whole lot of people begged you to take up that appointment.
I had, I call a spade a spade. When I was asked to act, it was really, when I was asked to act, I was asked if I would make myself available for the position. I think my acting stint was dependent on me saying I wasn't going to make myself available. But at the time, because I wouldn't do something I didn't want to do. But at the time, I had started to enjoy the work at the SCA, and I knew that I needed to grow as well. And I knew that I enjoyed judgment writing. I knew that I enjoyed being in court, and I knew that in Johannesburg I wouldn't get the opportunity as often as I would in the SCA to sit in panels and to be able to, be involved in decision making, judgment writing. So I think that was one of the main reasons why I decided that I would take. But also at the time, my heart had always been in the LCC, to be honest. And I've displayed that. I've But the position for JP the position, all the act had not come into operation by then. And, I'd been in the judiciary for more than 12 years. And I think, human nature, one wants upward movement. And so that wasn't available to me. And as I said, I'd enjoyed my stint tremendously at the SCA and got great value learning from colleagues. And so I thought at the time where I was, that's what I wanted to do at the time.
By my count, you've been a judge for 16 years now.
16 years.
4 of those spent at the SCA.
That's right, DCJ.
Okay. And during this span of 16 years and in all the courts in which you have sat, you have produced written judgments, some which have been reported.
Yes, DCJ.
And quite a few of them on land reform and land restitution. How many were upheld on appeal?
To the best of my knowledge, well, one was a review, a REVA, but of course it went to the SCA, and then the Concord, in a minority judgment, agreed with me. And then the other judgment was my LCC judgment, and brings back memories, Justice Mir. I recall that back then, restitution matters, 2 judges were allocated matters. And it was my first restitution matter. And I recall a day or 2 before the hearing, it was to be held in Cape Town, your mom later, Fatima Mir, passed away. And you had to attend a funeral, and I had to run with the case, which ended up all the way in the Constitutional Court. Mm-hmm. And the Constitutional Court basically confirmed my findings.
That was Florence.
Yeah.
Good. All right. You have been involved in a number of organizations that are concerned with the promotion of the advancement of women in society, in the legal field, particularly in the judiciary. And one of those is the South African chapter of the International Association of Women Judges.
Yes.
I mentioned this one because I know that you have mentored a number of young women who aspire to become lawyers, young women who are already in the profession, who are looking for a gateway in getting good work, and junior colleagues. Is that right?
Yes, DCJ. And I continue to do so.
Yeah.
I love training, and I love, if I hadn't been given a chance at the time, back in 1998, if the door wasn't open for me, I would not have been here where I am today. So I'm also clear that I need to transfer skills that I've acquired over the last 16 years to others.
Yeah. And you served in the gender committee of the Commonwealth Magistrates and Judges Association.
That's right,
as well.
yeah.
Mm-hmm. And you were an NEC member in JOASA.
That's right, yeah, an NEC member.
Mm-hmm. Well, let me come to the heart of things. You've applied for to lead a very important court, which, like the rest of our courts, is beset with a number of challenges, chief of those caused by, issues such as lack of resources. The minister knows very well about this. You would have had time to check what the situation is in this particular court, and I want you to tell us what you have found in that exploration, and if you have found that there are challenges, what you intend doing to address them.
Thank
so
you,
in short, I just want you to give us a brief vision of that court. Sorry, what you have in mind for that court.
Thank you, DCJ. As you would know me, I take everything seriously. I did go to the land court, as it is now known. The commencement of the act was on the 5th of April, 2024. And I went and I engaged with the staff members, with other judges. I spoke to the court manager. and the registrars to find out what the position is with the court and where they sat. I've got a list of reserved judgments. I've got a list of the number of cases that are outstanding. And, the difficulty with that court, and I really know this because I was involved at the time. Justice Meer was for almost 10 or 11 years when Judge Bum and Judge Gildenhuys retired. She was basically the only permanent judge at that court. So I would come in an acting capacity and others would come in an acting capacity. So that was a great challenge. And of course, fortunately with the legislation, judges there, I think 3 judges have now been appointed permanently to that court. So that was a great challenge. My vision for that court is, look, the most important thing I think with a court like that is that one must ensure access to justice, access to our courts. And land claims matters really come from all parts of the country. I traveled to places that I'd never seen before. I mean, I didn't know that a place like Wakkerstroom existed. So beautiful. Places like Dalton that I had to travel to hear matters, to hear witnesses. And that's one of the challenges and sacrifices judges make at that court, that they've got to leave their home and find themselves in very far off the beaten track places. But that's access to justice. That's what we have to do. This court, because most of the people that bring these claims are not wealthy people, they're the poor. And I always believe that, my own experience in that court is that once the litigants see a judge involved, somehow the process is trusted. They trust the process. They trust that everything's going to go according to, their own understanding of how things work. So my strategy for that court would be, one is modernization. There's just no getting away from that. That court has to be modernized. It's got to be digitized. Fortunately, I've got that experience. I picked it up in Johannesburg when I was the acting DCJ. I got thrown into the deep end with case lines. There's court online, and yes, they have hiccups, but my philosophy in life is no matter how little or how small the resources you have, you make the best that you can with the little that you have. So that's never, ever going to be an excuse for me that we don't have resources. We're going to have to fix and work within what we have. And the efficiency of the court, I'll do my best. Justice Meer has left a fabulous legacy in that court. She single-handedly ran that court. And my sense is that if I'll just be taking the baton from her. That court's been transformed. There are 3 women in that court from a gender perspective. 2 black females, 1 of African descent, 1 of Indian descent, and a white female, and 2 men, 2 males, while effectively one's an acting judge and Justice Nube. So from a transformation perspective, that court, has the face of the country, so to speak. It represents everyone. I'm a colored female of colored descent, so my face will just be added to that beautiful court, a rainbow nation. I think also I would like to work with and I have this view that, you can't work in boxes. We're all, the separation of powers, people tend to treat it as if, you're all in a box. I believe there's an interdependent relationship. The judiciary has to work with the legislator who makes laws. We've got to implement it. So that interdependent, this notion of the misnomer to be totally independent. So we've got to work with one another. And that's the culture of the LC. In my time there, Judge Meer's management style was to include all her judges. We'd be involved in interview processes. We'd be involved in going to meetings. We'd be involved in training. I recall we trained the new panel that got appointed to the new panel that I think that won the tender for litigation purposes. We had to train. I also had to train Botswana judges. So the culture in that court, which was a cooperative culture with the staff, very happy staff at the LC, I must say. And so for me, I would just be wanting to retain such a culture. But I think the most important thing now is, one, what does digitization bring? It brings about, better service delivery for our communities. It brings about a reduction in queues, in paper, just across the world. I mean, if you're looking at climate change, we'd be saving paper. We'd be adding to this wonderful thing of trying to save the planet. And I think also, for me, what was very striking during this whole COVID period was the access that people had to our courts. I remember in Johannesburg, we set up a court room for those who could not afford a laptop or data. They would be informed by your registrar or clerk to attend court, and they could make representations even if they were representing themselves. So digitization can work even in the most dire circumstances. One can find ways in which to find solutions. One of the things I've always said, especially with the land claims, and I know that us judges traveling has a huge impact on the budget, but something that we have to do. And the LC through Justice Mir have come up with an idea that what they'll do is go to the communities, hear the witnesses, let them see the process, and once all of that's done, to save costs, come back to the seat, which is in Randburg, and then continue with the trial. I'd like to even go one step further. I would like to suggest that through the Department of Justice, maybe the Ministry of Agriculture, Land Reform, and Rural Development, because I know that the Chief Justice, together with the Minister, can also, in terms of the new Land Act, can also direct that, halls and community centers can be used as courts. And I'd like to suggest with digitization that even those cases where you hear witnesses and have to go back to the seat, that the community can still be involved. You can live stream what's happening from these. I don't think it takes a lot of money to set up such a structure. We did it in Johannesburg. And so I would also suggest that, with digitization, the courts can even go to the communities in that way. And also, I think just also live streaming, most people have Android phones today, so I think, access is even greater in that respect. I think that the new Land Act, what I would like to encourage, and there's a huge emphasis on mediation and arbitration. I think it's a valuable tool to have, and I think that lots of matters are going to be finalized. With now having the court having the power to direct that, if you can see that matters can be resolved, direct that mediation takes place or arbitration. Those regulations still have to be thought through and have to be put into place, but it's a wonderful mechanism to try and also, litigate through not through mediation, but also to reduce the number of the litigation and expedite hearings. And I don't know, I read the Act quite carefully, and I'm not sure if judges are excluded from mediation. And I know in Germany the judges are part of the mediation, and then they don't sit in on the matter, like case management matters. I know that we just, in terms of the Act, there should be 5 judges in that court. So it's going to be a bit of a challenge because of, you may have to recuse yourself, and you've got such a limited number of judges. So I think the alternative dispute resolution is a fabulous tool that's been put into the new Act. These are non-judicial powers that comes through, that we find now in the new Act. So the new Land Act also gives the land court increased jurisdiction. And I think what it does, it will bring certainty and stability to that court. In a sense where all land issues will be concentrated in one place. People will not be confused. They won't have to run to the High Court, to deal with something to do with the Alienation of Land Act, or they may, so they'll know where to go to. It'll give certainty to people. The Act has also increased the jurisdiction of that court. And of course, the Act really creates two courts, the Land Court and the Land Appeal Court. So once again, instead of parties waiting to go all the way to Bloemfontein, because it never had full court status, the Land Court, all the way to Bloemfontein, and to wait in the queue, and Bloemfontein is so busy. I come from there. It's a very busy division. And I think matters will be finalized far quicker. And it will also enhance the jurisprudence of land issues. So I think I would like to, see that that's implemented in the most streamlined fashion. And again, digitization, it may come a time, I don't know what's the answer, but there may come a time when you require judges from other divisions to assist. And with digitization, you just have to put on your computer and 3 judges can sit as a full court. You don't necessarily have to come all the way to Randburg to have the hearings done. So, I believe with my experience, it literally feels like, often people ask me, so why are you doing this? Because, well, at the time, this position was never available. It's like coming home. I have been there for 12 years. I stayed because I had the option of not doing that work. And I actually, if memory serves me, I had to appeal to my DJPs together with Judge Bam and Judge Meer to release me to go and do that work. It was a struggle. I don't think people gave that court the credit that it deserved. It was almost a court that was relegated to the background, not treated with the how do I put it? With the seriousness that it deserves. I mean, land issues is one of the most important issues that this country faces, and we got to get it right. That's a long vision, DCJ.
No, it's not. Have you finished? Have you finished?
Yes, thank you.
Okay, thank you. Do you have any reserved judgments?
Not at all.
Yeah. Okay. All right. That's it from me for now.
Thank you.
Okay. AJP Meer, do you have questions for the candidate?
I have just 2 questions. Good afternoon, Justice Carelse. You've had a long and productive career in the judiciary, and you have been known at the Land Claims Court for your energy and as somebody who gets things done and gets things done efficiently. I'd like you to explain what in particular about your leadership role in the High Court would you bring to the Land Claims Court, or do you think should be transferred to the Land Claims Court, and which would hold you in good stead for the position you've applied for?
Well, I think throughout my career, even as a prosecutor, I was always identified with leadership positions, control prosecutor. I'd have to step in for the assistant. When I was a magistrate, I had to step in. I was tasked with setting up for the very first time sexual offences courts. And I think what I bring from the High Court, look, Johannesburg's very busy. It taught me time management, taught me to manage my work. I've not ever been on the list of reserve judgments. I've managed that very efficiently. And there's no doubt when you're sitting in the land court and you then have to go to Johannesburg, the work follows you. So there's no such thing as cutting off that I'm there for a particular time and that's it. I'm only going to open that file. I had to juggle my time through the evenings at night. And I think the experience I gained being in such a busy division in Johannesburg it will be with me. It's developed me as a person, as a judge. And the one thing I forgot to mention, Judge Meer, was one of the things that I found was quite effective even during my time as the acting DJP. As I said, during that period, during COVID, none of the cases came to a halt. We carried on, we finalized matters efficiently. And one of the good things that I found, and it's something that I would like to work on, is to engage the various organizations, the bars, the LPC, the AFT, NADAL, the rest, the BLA, and to try and encourage, because it's I don't know if people are afraid to come to that court. But the work is so interesting. And you get so much satisfaction when you've given a judgment that's changed people's lives, it's given them back their dignity, and restored their faith in the democracy of this country, when you just give someone something back and you acknowledge that they'd been dispossessed at some point in time. So we need a lot more help. We need a lot more people that are interested in that matter. We need a lot more skills from the profession, to engage these issues, because the issues are novel. Often you'll get a counsel and you'll get a junior counsel who hasn't any clue, and the issues are so, how do I put it?
So emotive.
Exactly, thank you, Judge Mir. And you'd really would like, you can't help, present someone's case for them. But that's the difficulty there. And I think that the more seasoned, experienced counsel get to grips with the Land Act, and I know for a fact they'll enjoy the work, but also they'll also be able to help towards the jurisprudence. But one of the things, coming back to what I actually wanted to say, one of the things was that Johannesburg, in my time as the decent acting deputy judge president, together with the JP Mlambo at the time, was the bar and all the associations were encouraged to come forward and give of their time to do pro bono judicial work. And it was a fabulous, fabulous method to try and reduce the workload, as well as, in fact, in the LC, it's hard to say LCC, I must get used to saying the LC. In fact, in the LC, I think it'll work fabulously, because you then get, practitioners to come for a week. You'd give them matters where it's probably an application or a trial, not really restitution matters, because with restitution matters, they take up your time, and it's difficult for counsel to give up their practice for a long period of time. So for me, I would try and encourage that. It would also encourage people to get to grips with the Land Act, and I'd hope that the senior members of the associations, think about that and offer assistance to that court.
I think some of the commissioners may be curious as to why a Supreme Court of Appeal judge would make a shift from the SCA to the Land Court. Okay. Do you want to say anything about that?
Yes, Judge Mir. I think someone said, well, why this is a demotion? I said, no, it's not a demotion. At the end of the day, I'm a judge, and where I have to serve. Doesn't matter what title I wear. I am very invested in that court. It's my passion. I've been there for 12 years. People spoke to me and said, I've got a lot of value to add to that court, and I must make myself available. So I certainly don't see it as a demotion at all. I just see that in fact, I'm even a better judge for that, because going to the SCA, I was actually fortunate because of my experience, I was assigned either as a scribe or as a panelist on LC matters. And I learned a lot from colleagues, but I also was able to share my skills with other colleagues, and often colleagues would phone me up and ask me, what do I think about it? So sitting as an appeal court with different views, managing all of that, I think I'm a better judge today than I ever was. And don't see it as a demotion, Justice.
Thank you. Nothing more from me.
Thank you.
Do you have questions for the candidate colleagues? Yes, Minister?
Yeah, I only have one question. You have addressed the issue related to the challenges of the capacity of the court, that the new act will help to bring the permanent judges. But the other capacity and challenges I've heard in the past was that also the matters, also being mindful of the separation of powers, that the commission was also struggling to process matters and so forth. And also the other leg that we have mentioned earlier of the tender from rural development, you will be aware that is now with the Legal Aid South Africa. So how will you enable the court to expeditiously deal with matters, considering that the entire value chain, that some of them may not be really in your hands?
I know that is the difficult part, Minister Lamola, but I think I've spoke to the court manager, and there's a task team that's been set up to try and capacitate the court. But I spoke to the court manager, and she believes that as the court stands right now, things will come in slowly, that the court is capacitated to manage whatever comes in. Of course, we can't go looking for cases, unfortunately. We can't, we can't tell people to bring cases to us. But I expect an influx of cases, but I think that working with both the Department of Justice as well as the Rural Development, and I think that everybody certainly is committed to that court working, I can't see any challenge not being able to be overcome.
Thank you, DCJ.
Yes, Commissioner Matulutlepu, you can go ahead.
Okay, thank you, DCJ. Good afternoon, Justice Carelse. Well, you spoke about the innovation about mediation, and I love mediation.
Sorry, I can't hear.
I'm saying I love mediation because I'm a mediator.
Okay.
But the problem, what I've seen is that it does not bring the relief that it's supposed to bring because it's a voluntary process.
Yes.
So how do you think you can actually encourage parties to really go for mediation, especially in a sense of the land claims, when we know that land claim is a political issue and a very,
Well, I think if I understand the new Land Act, I think that the presiding judge has the power to direct mediation. So it's not a voluntary thing. If you're sitting with the matter and you see that this matter can be resolved through mediation, then you give that direction. I think you can even stop the proceedings and say, no, this matter must stop. We're going to suspend proceedings and we're going to direct that mediation takes place. So it's putting that process, through the department, I think, with the regulations and how to ensure that people are, trained, skilled, understand, because I think that's going to be quite a bit of a challenge to get people with the necessary skills. And I think they are there. They just need to, come on board and assist with that. So that's the one thing. And I think also, even if judges are not allowed to mediate, I would imagine that we should keep judicial oversight, since it's our order that we're given direction to. So we will control that process by an oversight role during the mediation process.
Thank you, DCJ.
Thank you, Commissioner Matulutlepu. Commissioner Nyambi?
Thank you, DCJ. Afternoon, Judge.
Afternoon to you.
One question from my side. As we know that the issue of land, it's an emotive one in our country. Anything that stand out, because you are valuing yourself for a leadership position coming from SCA to the Land Claims Court. Anything that you have experienced as a legal practitioner or a judge?
Everything that I...
Anything that you have experienced that will demonstrate that was a challenge that you have come across that will demonstrate that you are ready for this leadership position? Your worst experience as a judge that you are able to deal with in a way that will show that you are ready to lead this very important critical court?
Thank you for that question. In fact, you remind me of when I first came to Johannesburg, and I recall that we were three female judges. And there was one time I was given a allocation of I just want to tell you about my personality and how I go about taking on challenges. And I recall that it was a 100 million rand tender. And as people that know Johannesburg, there was a time when you would get to 400 cases, unopposed matters, to finalize it on Tuesday, and then Tuesday afternoon to start with the opposed matters. And in came a barrage of very senior counsel, very lily white, and sat in the courtroom and, of course, asked to address me and says, well, am I ready to hear the matter? So I said, yes, matter will stand down, and in a half an hour, we'll hear the matter. So those were the challenges. I prepared myself for that. And, when I'm given a challenge, I don't think I shy away from a challenge. In fact, people that know me know that I'm no pushover. And if I am committed to something, I don't do it 50%, I do it 100%. this new sort of land court, the act, it will be treading completely new ground. And I know that I'm looking forward to it because it's a challenge, and as I said, the culture in that court, look, Justice Mir, I know that she's going to be available. With that kind of institutional knowledge and memory, I would be a fool not to think that I can't, access her and ask her for leadership advice. And there's many people in the judiciary. There's my deputy sitting across from me, from the SCA, that's going to retire. He knows I call him very often when I require advice. So I'll not be treading in the dark alone. I know it's a new area, it'll be new things being set up, but I'll get the assistance that I require.
Thank you, Judge. Thank you, DCJ.
Thank you, Commissioner Nyambi. Commissioner Clark?
Thank you very much, DCJ. Good morning, good afternoon, Judge Carelse. I hope I'm pronouncing it correctly. All right. Judge, there are two sets of claims. The first set is the, call them, the old order claims.
Yes.
And the second set is the new order claims.
Yes.
And if you go around, you get people asking a question. We belong to the second set, the new order claims. And no one comes with an explanation as to when are we going to get our claims settled. And what do you think is the bottleneck? Or where do you think the bottleneck rests before these, especially the second one, could be addressed?
The way I understand it, I'm sure there's a moratorium, Constitutional Court, I think in land movement matter, if I'm not mistaken, placed a moratorium on all claims. The Concord said that the first set of claims must be finalized. I think gave the department 2 years, but I don't know if it's been revived again. I'm not sure of it. I think they were meant to revive the moratorium because I think it would have lapsed it had 2 years in which for them to finalize the outstanding claims. So the way I understand it, I think there's a moratorium on claims, the new order claims. They were meant to finalize, and I think, there was meant to be reports, and so I don't think it's done.
So where do you think the problem lies?
Well, I don't think the judiciary can help with that. I think it's a question for the departments, the Department of Justice, Rural Development, to go and maybe revive that or expedite the matters. So the bottleneck probably lies at the administration, because at the LC, the cases that are in front of us, I think that come before us and are ready to be heard. All kinds of means are done to hear matters. But I think that the Concord, the way I understood it, so the Concord ordered that all the old claims had to be finalized before the new claims were to be dealt with. So I don't know whether they're just standing, whether they're waiting to finalize, whether they're being processed. I don't know any of that. That'll be a question that the department will have to answer. Unfortunately, I don't have that knowledge.
Let me rest at that, DCJ. Thank you so much.
Thank you.
Prof. Marumagai?
Thank you, DCJ. Good day, Judge.
Good afternoon.
I just want to ask something. I've been checking this act out.
Yes.
And I was quite intrigued by section 12 or section, I think, the one that deals with assessors.
Assessors, yes.
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 I was quite intrigued at how it has been drafted. I'm not gonna burden you with the details. I just want to get your sense. And of course, you'll draw on your experience. When I look at this section, it seems to us to suggest that there will be a need for assessors. But it is not quite clear from my reading as to in what circumstances would a judge decide to sit with assessors in land claims court. And it's quite different as to how it has been drafted with how assessors are kind of like used in the Criminal Procedure Act. What is the role of assessors and what value are they bringing in the adjudication of matters before the land claims court, the land court?
Okay, yes, you are right. I think that the land claim, the amendment, before the amendment, I think that assessors were almost peremptory for assessors to be used in restitution matters. Now it's not peremptory. Now judges have almost the discretion to use assessors or not. Assessors have been plagued that court, people that are not making themselves available as well. Assessors, I think, in my experience, when I did my restitution matters, assessors, you'd normally get a valuer. So basically, you know, they give an idea, the value of the land and how to assess that. But basically, I've never worked with an assessor who didn't have that skill. So that's where the value comes in, when you have someone who's got that skill, because judges are not valuers. You don't understand how they value a property. So that's how I did. That's what I did. But I know that the land court has made representations, they've made submissions about the question of assessors and asked that the regulations be drafted in a certain way because of the various challenges. And I know for a long time we couldn't get assessors in the land court because we had to fly people from all over. There was a limited amount of assessors, most times because people were not paid well, and I think there's still a debate of what they're going to be paid in the future. Currently, I think they get paid 3,500 Rand a day. But if you look at the Act, it doesn't seem that that's where they're going, you know, and there'll be full-time, I think full-time assessors or something to that effect. So it does pose a challenge, but in the past, you really couldn't go on with the restitution matter unless you have an assessor. Now you can carry on without it. It depends on the facts in the case and how intricate it is. I suppose a judge will have to apply his or her mind to see whether or not it's required in the circumstances.
Thank you very much, Judge. It seems a little bit weird to me, but thank you very much for that explanation. Thank you very much, DCJ.
Well, I just add that the problem with using assessors, not just confined to the land claims court, it affected the high courts as well.
Yes.
And because of all these budgetary constraints, and it's just a resource that the courts have had to learn to do without.
Yes.
Do we have any questions from the colleagues on the virtual platform? No. Is there anyone on that platform at all? Yes. Okay. All right. Thank you, colleagues. Oh, well, that was quite a short interview.
Yes, thank you.
Justice Carelse.
I can rush up and break my fast.
We've reached the end of our business with you today. I just want to thank you again for your patience and for listening to all the pleas that were sent your way to make yourself available for this position. I know how much you love being in the SA. So
thank you, JSC.
Thank
you,
you.
Commissioners. Thank you very much.
You. Unless you have any questions for us?
No, I'm fine, thank you.
You're excused. Thank you so much.